Let's review an example. Ted is a part-time employee of Mountain Properties, LLC, which owns several apartment buildings. Ted is able to complete his duties in managing the properties in 20 hours a week. Ted seeks employment with Lakeview Properties, LLC, to perform property management services on a part-time basis. Does Ted need a license? Yes. While he is and would be an employee of both owners, the statute specifically limits Ted to one employer when performing property management functions without a license under this exemption. The statute also allows a resident manager to manage the complex in which they reside in exchange for free or reduced rent without a license. The resident manager does not need to be an employee of the owner, but may only manage the complex in which the resident manager resides. Let's assume George lives in an apartment in a complex with 6 buildings. George manages all buildings in return for free rent. Does George need a license? No. Clearly, this falls into the exemption we just discussed. Let's change the situation a bit. George still lives in the apartment rent-free. Not only does he manage the complex in which he lives, but he manages another complex owned by the same individual across town. Does George need a license? Yes, George would need a license. If the method of compensation is free or reduced rent, the unlicensed individual may only manage the complex in which they live without a license. If George wanted to manage another complex owned by the same owner, he would either need to be a regularly salaried employee of the owner or obtain a real estate license. HOA exemption. A regularly salaried employee of a homeowners association may perform property management functions for the association without a license. The same requirements apply regarding the definition of a regularly salaried employee. Property management employees. The statute also contains an exemption for regularly salaried employees of property management companies. This exemption is very detailed with several requirements. While the exemption is in the statute, the details of the exemption are found in the rules. An unlicensed employee of a licensed property management company may perform the following functions: provide a prospective tenant with access to a vacant apartment, provide secretarial, bookkeeping, maintenance, or rent collection services, quote, predetermined rent or lease terms, fill out pre-printed rent or lease agreements. Hopefully you picked up on the idea that the unlicensed person working for a licensed property management company is very limited in what they're able to do. We discussed the particulars of a property management firm in another course. The statute also provides an exemption for a person acting under a power of attorney from the owner of a property. For example, if an owner was out of town for the closing of their property, they could appoint someone to act on their behalf at the closing using a power of attorney. The appointed person becomes an attorney in fact and may facilitate the closing without a license. Attorneys also have a somewhat narrow exemption. If an attorney is required to assist in a real estate transaction in the normal course of their legal practice, they may do so without a license. As should seem logical, anyone acting under the order of a court may comply with the order without a license, even if the order requires something that would otherwise require a license. Trustees under a deed of trust may also perform their duties without a license, even if their activities would otherwise require a license. Utility companies such as power companies, gas companies, water companies, and the like often need to engage in real estate transactions. For example, they may need to negotiate a land purchase or easements to run utility lines. The statute allows for public utilities to participate in real estate transactions without being licensed, as long as the transaction is directly related to their role as a public utility. Finally, if a securities transaction includes real estate, the individuals involved in the transaction do not need to be licensed as long as they are licensed as a broker-dealer or investment advisor under the appropriate state and federal laws. We've discussed many licensing requirements and exemptions. Please note, these requirements are established by law and carry penalties for violations. The law does not provide for any one-time exemption. If an individual is participating in real estate transactions as we've discussed, they need to be licensed.